In response to my learned colleague's application for pre-charge detention, we would wish to state as follows.
So you oppose the application?
We oppose the application now. For the following reasons. When holding an arrested person beyond the 24 hours prescribed under Article 49, 1F, holding charge against the accused person. And it is our submission that the police have no authority, Your Honor, in law to arrest and detain any person without sufficient grounds if this trend continues, it will erode all the gains made in the advancement of human rights and fundamental freedoms as provided for in the Constitution. Your Honor, the prosecution has not detailed any compelling reasons to warrant the continued pre-charge detention. They've only stated that they're apprehensive, that the respondent is a flight risk. Your Honor, mere apprehension cannot be a compelling reason for a continued pre-charge detention. The accused person has a fixed abode that is in Westview Estate near Equity Bank. In Watertown, in an estate known as Westview Estate near Equity Bank. If at all required by the police, she undertakes to cooperate and she will avail herself. Further, Your Honor, the accused person is a civil servant, a teacher by profession. She is a teacher by profession. Holder of TSC number 2648 62 and is still in employment.
Teacher, TSC number
26 for employment, Your Honor. They cannot be in a position to get hold of their case if at all they really want to. There's no proof of the alleged interference or threat to witnesses by the prosecution. It's just a mere apprehension, which cannot suffice in law. On the
the charge that she may face of attempted murder and decides that it's not worth the risk. The seriousness of the offense does increase the temptation to abscond. You know, it's noteworthy that the respondent was arrested at the scene of crime. She was arrested at the scene of crime on the morning following the incident. She frequents the said hotel and is likely to interfere with witnesses.
She
Frequents the scene, the hotel. The chances of interfering with the witnesses and the evidence, which includes a CCTV, are high. That is why the prosecution continues to urge the court to grant the DCI the said 7 days to finalize on all investigations.
You understand English? Huh? Understand English?
Yes.
The application before the court for determination is the notice of motion dated 7th of December 2020. In view of the order sought in the application that is by two, I find the matter urgent, 736 custody orders. I therefore certify the application urgent. It requires two of the application, the applicant seeks an order that the respondent be detained in police custody at Remanded police station for 7 days to enable the investigation of the PC Jason Matete to complete investigations. The application is supported by an affidavit shown by the investigator of the PC Jason Matete, whose contents I have carefully read and considered. I have also considered the oral submissions made by the prosecution counsel, Madam Mekira, in support of the application, and the oral submissions made by Madam Wadambo. The key consideration for the court to determine is whether there are compelling reasons as contemplated under Article 49. Bail. The respondent's advocate has submitted that the reasons advanced by the applicant that the respondent is likely to interfere with investigations have not been proved. The scenes of crime at 3D apartments and 3D restaurant are public places. It is difficult for the investigating officer to secure the scene of crime at a public place when the suspect is served on bond or bail. I find that there is a high possibility of interference of the scene of crime by the suspect herein if she is released on bond or bail. She may also interfere with witnesses who are yet to record statements. This is more so since the suspect is said to be a common visitor in those premises. Even though no OD charge has been preferred against the respondent suspect, the possible offense he is likely to face has been sufficiently described in the application and the supporting affidavit as attempted murder. In my view, the suspect that the respondent already has been informed and knows the possible charges of attempted murder or even murder in case the victim who is in ICU dies. I find that the applicant has complied with Article 49 of the Constitution. By informing the respondent the reasons for the arrest and the possible charges which are likely to be reversed. The possible offense of attempted murder or murder which is under investigation is serious and requires thorough investigations. The matter is of great public interest, noting that the alleged victim is a senator. Due to great public interest and the serious conditions, that is, intensive care in which the alleged victim is in, is likely to tempt the suspect to abscond, released on bond or bail pending investigations. No documents from the Teacher Service Commission have been produced to show that the respondent is a professional teacher. Further, no tenants agreement has been produced to show that the respondent has a fixed abode at Watertown, Makueni County. Even if such documents are produced, they cannot eliminate the possibility of absconding. The facts of this matter are different from those in Nakuru High Court Criminal Revision number 208 of 2020. That is sued Oscar Kipchumba versus the Republic. In the Nakuru case, what was under investigation was hate speech, assault of police officer, offensive conduct, unlawful possession of firearms, and resisting arrest. The victim in the Nakuru court case had not been admitted in the intensive care unit. The possible offense herein is attempted murder or murder and are more serious than those in the Nakuru court case. Although the respondent applicant in the Nakuru court case was a city member of parliament and unlikely to abscond, I do not see or contemplate any possible bond and or bail terms which can eliminate the possibility of absconding or interfering with the witnesses if the respondent here is released on bond or bail pending investigations. There are no less restrictive means to achieve the order sought by the applicant, stroke investigator. The fact that the alleged victim is admitted in the intensive care unit complicates the matter. It is necessary to detain the suspect for a while to see whether the condition of the alleged victim will improve. The suspect was arrested on the 4th day of December 2020, and the 7 days sought to complete investigation is not a long time, given the complexity of the investigations. Most of the school students in Kenya are at home due to the coronavirus pandemic. The respondent will not suffer much prejudice and is unlikely to lose employment if indeed she is a teacher by being detained for only 7 days. In any case, such employment has not been proved. At the end, and considering all the facts and the materials tabled before me, I find that there are compelling reasons not to release the respondent on bond or bail at this stage. The application dated 7th of December 2020 is therefore allowed in terms of prior to the application. The respondent stroke suspect will be detained at Kilimani police station for 7 days with effect from today to enable the investigator to complete investigations. There will be a mention for further orders. That are mentioned after.
Must oblige.